During the Civil War, vendors committed fraud on the Union Army, including by selling the Army sick mules. In response, Congress passed the False Claims Act, which provides a cause of action against anyone who submits false claims to the federal government. In modern times, the federal government frequently uses the False Claims Act to police fraud and abuse in healthcare. Concerned individuals may also file lawsuits called qui tam actions, alleging violations of the False Claims Act. Qui tam actions are covered in a separate lesson. The False Claims Act has a civil and criminal version. We'll start with the civil one. For a civil violation, a violator can be expelled from the federal Medicare program, be required to pay triple the government's actual damages, and be required to pay civil penalties ranging from $11,000 to $24,000 per false claim, even if the government suffers no damages. For healthcare providers, each separate request for payment or code on a billing statement may be considered a claim, which can quickly add up to a significant liability. For instance, a 2015 False Claims Act case resulted in a judgment against a healthcare provider for over $237 million. Further, civil actions for false claims may be filed up to 10 years after an alleged violation occurs, which increases the Act's enforcement power. As the name implies, the False Claims Act prohibits claims based on false information. Although there are many ways to violate the Act, essentially any factual or legally untrue statement submitted as part of a request for money from the government is a false claim. In healthcare, common false claims include the submission of an untrue claim to Medicare for a service or level of service that wasn't actually provided, or the submission of an untrue record supporting a claim for Medicare payment.